Hi, I'm Shannon Ferrell with Oklahoma State University, and today I want to tell you about 5 reasons that you need to have a written lease for your agricultural leasing agreement. The first reason is that in many states you have to have a written lease, especially if your lease agreement is going to last longer than 1 year. Most states require that those kinds of leases have to be in writing. For various other legal reasons, your lease may have to be in writing to be enforceable, so that just makes it a good idea. Number 2 is that having a written lease is actually a really good brainstorming and discussion tool. As a result of you and the other party, whether that's a landowner or an operator, talking about what needs to be in the written lease, you actually realize that you flesh out a lot of the details that you wouldn't have thought about otherwise. The third reason is that it provides an excellent means for dealing with the unexpected. If there are situations that arise that neither of you really foresaw, like what happens if the landowner passes away, or what if the tenant passes away, or if there's a sale of the property or something of that sort, an oral agreement isn't going to be able to withstand that kind of a change. But if you've contemplated that kind of change in your written agreement, you can actually make that sort of transition. The fourth reason is it will allow you to flesh out some of the very specific details that you need to have in your lease agreement. What kind of cropping practices are going to be allowed or won't be allowed. If we're talking about a livestock lease, what kind of activities, what kind of grazing rates will be permitted, what won't. We need to sort of sort those things out early so that there aren't disputes on down the road. Which leads to the fifth point, and that is that sometimes good fences just make good neighbors. The reason that I say that is so many people say that they want to have an oral agreement because they think that shows more trust on the part of the parties, but in actuality that often gives us more of an opportunity for there to be disagreements that can lead to harsh feelings and a break in the business relationship between the landowner and the operator. On the other hand, if we take some time and really talk these things out, put them down in a written agreement, they serve as a reminder. So if we have a question about whose responsibility is what within the lease, we can go back to the agreement, find it out quickly, and resolve that dispute. So those are the 5 reasons that I think everybody ought to have a written agreement for their agricultural land lease.